They were really trying to block everything. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, by now, most of you guys might have heard that there has been a final decision when it comes to the lawsuit against the city of Moscow that was filed by Karen Laramie, who is Maddie Mogen's mom. Now, there was a temporary order regarding these things, but when it came to the photos in the body cam that we had seen so far, there was already a lot of blurring and a lot of redactions. And honestly, after reading all 14 pages of this document that came with the judge's order, I don't really think that anything is going to change based off of the things that we've already been getting. But I'm going to go ahead and jump off the screen and read the entire 14-page document to you guys now. I'll be back in a few. Now, as you can see, this was filed yesterday, October 1st, 2025 in Latah County. Memorandum decision granting in part plaintiff's complaint for permanent injunction. This matter is before the Court of Plaintiff's Complaint for Injunctive Relief seeking to restrain and permanently enjoin the defendant, City of Moscow, the city, from releasing certain records related to the homicide of their family members pursuant to IR CP 65 and IC 741241C. The background. On November 13th, 2022, 4 University of Idaho students, Maddie Mogen, Kaylee Goncalves, Xana Kernodle, and Ethan Chapin, collectively decedents, were tragically murdered in Moscow, Idaho. The events took place at 1122 King Road, a private home shared by Mogen, Goncalves, and Kernodle. At the time of the murders, Chapin was staying at the residence with Kernodle. This is true. In the hours and days following the incident, multiple law enforcement agencies partnered to investigate and process the crime scene. Among the first to respond was the Moscow Police Department. As part of the investigation, videos, photographs, reports, and other evidentiary materials were generated, which ultimately led to Bryan Kohberger's arrest. For a multitude of reasons, the criminal case garnered worldwide interest. Until July 2nd, 2025, the criminal case was pending trial, and until July 17th, 2025, a non-dissemination order was in place, which prevented the disclosure of certain records to preserve the parties' right to a fair trial. On July 23, 2025, a judgment of conviction and commitment was entered, including the criminal proceeding. Yeah, everything changed. On July 23, 2025, the city has received over 1,150 public records requests for information related to the criminal investigation, including but not limited to crime scene photographs, 911 calls, police reports, body camera footage, witness statements, autopsy reports, and MPD investigatory records. Yes, I've filed several myself. In response to the requests, the city made redacted police reports available to the public via a web link and disclosed 186 photographs taken at the crime scene, some with blurring over the decedent's bodies. Actually, we never got those. We only received a few that we got from the mainstream media that were extremely blurred out, but I put a link for that in the Google Drive, and there's not very many. Now, the Idaho State Police gave us a whole bunch, but as far as Moscow itself is concerned, when it comes to their website, this is what it looks like. There's a link for it down in the description box, but this is all supplemental reports. You click on them, it downloads a file with all 50 or so in them, but there's not a file of just photos. This video here is all of the photos that we got from them. They were released to like a local station, and the local stations only put out a few out of all of them. So technically, when it comes to Ryan Snyder's supplemental report and his body cam video that we've gone over, we have yet to actually have the full list of photos visually in front of us. We've only had photos given to us from the Idaho State Police, and as you can see, they've given us 3 different batches, right here, and right here. This right here is all of their own reports on the case. I haven't seen anyone that has the full 186 photos that's being mentioned in this for everyone to view. I know I haven't received them. So if you guys know where those actually have been put out there for the public, please let me know down in the comments. On August 11th, 2025, the city provided copies of these photographs and certain redacted video to plaintiff's counsel and informed counsel that the city would be disclosing the redacted videos, including redacted body camera videos from MPD officers that depict the crime scene, as well as other materials within the coming days. Upon reviewing the photographs and video provided, plaintiff's counsel emailed a response to the city objecting to the release of any additional materials in this case because it would constitute a violation of plaintiff's personal privacy. Now, I will say that in one of the photos that we did get to see from MPD that was released through local media, we did see one of Maddie's room, and it looked like her underwear were right next to her jeans and her black boots that she had on that night. That's as far as when it comes to something super personal that we actually did see in these. And I understand, again, the reasoning why the parents would want this, the reason why Maddie's mom would want this. But this in the long run causes a more severe issue than just privacy rights. And I know that's going to sound one way or another to a lot of people, but this puts a complete stop to us seeing the knife sheath. Unless they do some sort of finagling with their photo editing or whatever, this stops us from being able to see the photographs that were taken inside Maddie's room when it comes to the way that the knife sheath was actually placed on the bed. Was it fully covered like Moscow Police Department claimed, and then the blanket had to be removed like the FBI claimed, and then voila, there it is? Or was it partially covered the way that ISP's reports make it sound? So it would seem like we would have heard about it from a lot more people than we have heard about it from. But all of the initial reports so far, no one mentions anything about a sheath in the reports themselves. And we can't tell if anyone is mentioning it with their voices in any of the body cams that we've seen so far, because they've silenced or beeped out a lot of really important context. And for a case where the only suspect is already serving life sentences, why are we still silencing the details? Why are we still not just putting it out there, giving us the truth, giving us the facts? The secrecy that continues is what makes this so beyond done. There's just way too much left here. On August 12, 2025, Karen Laramie, Mogen's mother, filed this complaint for an injunction restraining the city of Moscow from releasing further images related to the homicide investigation of plaintiff's daughter. Along with her complaint, Laramie filed an ex parte motion for temporary restraining order under IRCP 65B. Following an in-camera review of 4 redacted body cam videos and approximately 181 photographs, an order granting plaintiff's motion for temporary restraining order and a temporary restraining order were issued on August 15, 2025, that temporarily restrained the city from disclosing any images, audio, or video depicting the inside of Mogen's bedroom until a hearing on the preliminary or permanent injunction. On August 21, 2025, the city released additional body cam videos and crime scene photographs that blacked out the bedrooms entirely in lieu of blurring the decedent's bodies. Well, that is true. All the body cam that we have got since, all the photographs that we've gotten since, they're not letting us see anything when it comes to the bedrooms, regardless of if it's Bethany's, even the empty room on the bottom floor with Bethany. They're not letting us even see, like, as they're walking past that doorway with the door open. They're not letting us see literally anything. On August 23rd, 2025, plaintiffs filed their first amended complaint, adding Stacy and James Chapin, Chapin's parents, and Maisie Chapin, Chapin's sister, as plaintiffs. Plaintiffs seek a permanent injunction restraining the city from releasing, number 1, images of the interior of victims' residence. Well, that would mean the entire house. Number 2, images of the victims, whether blurred or not. Number 3 is images of the bedrooms where the victims' lives were taken. And number 4 is images of the death scenes, including images of pools of blood splatter, and dried. Now, I'd understand if they don't want us to see the pooled areas because that would be right at the bodies. But for us not to see anything that's dried, like, the sink that's mentioned, that dried blood is in one of the body cams that has been released here recently. But to also not let us see the splatter, how it landed on the walls and things like that, I don't see what the problem with that would be. I really just don't. The main thing that I'm really concerned about here is the knife sheath, because that was the strength of the state's evidence, and everything regarding it is completely questionable. And what came from it regarding the DNA, there was a narrative created between both sides that Brett Payne was supposed to get on the stand and under oath basically tell a fabricated tale. That's important, and that's why we're still digging into things here. Number 5, images of the personal property and items of the victims of the homicides found inside the interior and exterior of the residences, including but not limited to containers of alcohol, underwear. I told you that was going to be a big factor here. ID cards or other personal items. Okay, well, to say that you don't want us to see containers of alcohol in a house where there were people of legal age to drink or also living is really just a big, huge stretch. You're going too far. You're going way too far. As far as ID cards, they already block all that stuff out. But to say also the exterior of the residence, so you don't want us to see the vehicles that have already been all over social media and all over the internet for the past 3 years, this is going too far with things. This is them literally trying to stretch it as far as they possibly could for what? This is where it stops having a stance of importance and it starts getting chipped away a little bit at a time. I can agree to a certain extent, but whenever you start being like, oh, you can't show the alcohol in the room or the cars outside, you're doing just too much. I'm sorry. It's just too much. Number 6, images of witnesses, including witnesses hugging each other and sobbing. Well, that's part of the initial body cam. And that's also part of what Dylan did in court. So it's too late for that too. And also, can we say that the 2 actual family members that were there during the 911 initial body cam videos are not sobbing? Like Hunter Chapin and Maisie, Hunter is pretty much just like stunned. I don't really think he's really comprehending the scene he's standing in at the moment, so you really don't hear a lot from him at all. And then we've also heard that Maisie basically was just telling Dylan to shut the F up because she was getting on her nerves. But when it comes to all the crying and stuff like that, it's the friends, it's the people that came across the scene, which I get. But for this to be something to have to do with the family members that were there aren't the ones that we're hearing doing those things, if that makes sense. Number 8 being video and audio media containing statements of witnesses given to law enforcement officials, including statements evidencing their extreme emotions. So this is them wanting to make it to where we don't get to see any interview videos, nothing at all in way of anybody talking about anything. I'm sorry? What is happening here? Why in the hell would you even think that going to these links to try to silence information coming out about this case is the way to go? It's like they love the chaos, bro. It's like they freaking just want to keep feeding it and feeding it and feeding it. Damn. On August 25th, 2025, the parties submitted a stipulation of the parties submitting this matter for a decision on the permanent injunction based on the declarations, pleadings, and briefing on file. On August 28th, 2025, a hearing was held on plaintiff's complaint via Zoom. Attorney Leander James appeared on behalf of plaintiffs. City of Moscow attorney Mia Batista, attorney Andrew Pluskal, and attorney Bentley Stromberg appeared on behalf of defendant City of Moscow. Following the hearing, the court took the matter under advisement and issued an amended temporary restraining order which prohibited the city from disclosing any images, audio, or video depicting the inside of bedrooms of Mogen, Goncalves, and Kernodle. Now, again, I would like to be able to see placements. Like, I don't need to see their actual bodies. I don't need to see wound for wound. I don't. But I would love to see placement, initial placement. How was Kaylee actually laying in the bed? Because the Goncalveses have told us that she was sitting up in the corner, sort of slumped over, and Christy went on a whole thing about it. But then we get the information and the reports, and she's laying actually like all the way down, her head apparently on a pillow that doesn't have too much stuff on it if you want to compare what we're seeing to what we've heard when it comes to her specific facial injuries. So there's a lot of questions there, and really just original placements. If you got to blur the majority of their faces and things like that, okay. But I would, again, just really, for the sake of trying to figure out the truth, really love to see just the placements, initial placements. That's as far as I'd like to go. Now, having considered the evidence, pleadings, and argument, the court issues the following memorandum decision granting in part plaintiff's complaint in permanent injunction. Here is the legal standard. Pursuant to Rule 65 of the Idaho Rules of Civil Procedure, a party may petition the court for an injunction and or a restraining order in a civil proceeding. While Rule 65 addresses temporary restraining orders and preliminary injunctions, it only briefly addresses permanent injunctions by stating that before or after beginning the hearing in a motion for a preliminary injunction, the court may advance the trial on the merits and consolidate it with the hearing. Here, the parties stipulated to essentially forego a hearing on a preliminary injunction and instead submit the matter for a decision on the permanent injunction at the August 28, 2025 hearing. Unlike a temporary injunction, a permanent injunction is entered at the resolution of the case and requires a showing of threatened or actual irreparable injury. And it cites Gem State Roofing Inc. versus United Components Inc. from 2021. Further, in order to deny a permanent injunction, the trial court must be persuaded that there is no reasonable expectation that the wrong will be repeated. Quoting O. Bosky versus First Federal Savings and Loan of Boise from 1987. Okay. Analysis. Idaho Public Records Act. In accordance with the Idaho Public Records Act, or IPRA, there is a presumption that all public records in this state are open for inspection except as otherwise provided by statute. IC 741021. The IPRA provides a statutory mechanism by which members of the public may review public records so that they may be knowledgeable of the operations of their government, the performance of public officials, and the formulation of public policy. And it cites Wade versus Taylor from 2014. A public record is defined as any writing containing information related to the conduct or administration of the public's business prepared, owned, used, or retained by any state agency, independent, public body, corporate, or politic or local agency, regardless of physical form or characteristics. Every person has a right to examine and take a copy of such public record, but the motivation of the person requesting the public record is irrelevant. The public's right, and consequently any individual person's right to inspect a public record, is conditioned solely on whether the document is a public record that is not expressly exempted by statute. And again, it mentions Wade. Specifics to this case: law enforcement investigatory records are public records. Investigatory record means information with respect to an identifiable person, group of persons, or entities compiled by a public agency pursuant to its statutory authority in the course of investigating a specific act, omission, failure to act, or other conduct over which the public agency has regulatory authority or law enforcement authority. Generally, investigatory records, as defined by IC 741016, are subject to disclosure under the Idaho Public Records Act. When a request to examine is made, the public agency or custodian has a specific time in which to review the record and grant or deny the request. There are certain exceptions to disclosure as enumerated in IC 741241A through G that justify a public agency denying a request. One exception is where production of records would constitute an unwarranted invasion of personal privacy. An unwarranted invasion of personal privacy means disclosure of information used to identify, locate, or harass a juvenile, a victim of an alleged crime of mass violence or DV, or a victim of physical or SA. Well, we know a juvenile is not involved in this situation, so okay. The next one says, disclosure where release of information is likely to violate legitimate and substantial privacy interest of the person identified when such interests are weighed against general public information. Okay, so basically just your basic actual privacy information, okay? IC 7410117A. The parties agree that the records to be disclosed in this matter are public records, and more specifically, law enforcement investigatory records. The inquiry for the court is whether the specific records are exempt from disclosure under IC 74-1241C, such that the city would be restrained from releasing them to the public or any specific requester. Plaintiffs argue disclosure of the public records, specifically photographs, audio, and video created by law enforcement at the crime scene or decedent's residence, would constitute an unwarranted invasion of personal privacy, and therefore the city's disclosure would violate IC 74-1241C. On the contrary, the city argues the records are not exempt from disclosure because plaintiffs do not have standing or authority to assert a privacy interest either on behalf of themselves or on behalf of the decedents, and if plaintiffs can establish a privacy interest, that interest is not outweighed by the public's interest in disclosure. I mean, honestly, it's not going to really matter what we end up reading here, to be honest, because they've already been doing it since before this was even written up. You know what I mean? They've already done all of the redactions. It's not like they're going to send out new versions of things. Plaintiffs have standing to assert a privacy interest in the records to be disclosed. First, the court must determine what privacy interest, if any, plaintiffs have in the law enforcement records they seek to keep from public disclosure. To determine this, the court must look to the language of the statute and the cases which interpret what constitutes an unwarranted invasion of personal privacy. To begin, IPRA defines an unwarranted invasion of personal privacy as either disclosure of information used to identify, locate, or harass a victim of an alleged crime of mass violence, or disclosure where release of information is likely to violate legitimate and substantial privacy interests of the person identified when such interests are weighed against general public information. Plaintiffs argue the plain language of the statute confers standing for them to bring this action because the information being disclosed depicts the victims' bodies, which identifies the victims and may be used to harass the family members who are considered victims as set forth in IC 195306. Okay, but everyone already knows, y'all. This case has been going on for 3 years. We literally already know. This victim's rights statute specifically defines victim as an individual who suffers direct or threatened physical, financial, or emotional harm as the result of the commission of a crime. So I understand the emotional portion of this, but again, we already know who you guys are. Y'all have all been on camera. Y'all have all done interviews. We know the victims' names. This is a useless, pointless argument to me. Further, plaintiffs argue the language, privacy interest of the person identified, is the person who identifies as having their privacy interest violated. Contrarily, the city argues that because the privacy interest of family members is not specifically mentioned in the statute, the legislature did not intend for such to exist under IC 74-1241C. Moreover, the legislature specifically defined the privacy interest of any deceased person in IC 74-10117B when disclosure of certain information is permitted after notification to next of kin, but opted not to include the same definition in 17A. The city acknowledges in drafting this provision that the legislature recognized privacy interests do not evaporate on death, yet argues because it did not include the same language in 17A, such provision does not grant plaintiffs standing to assert a privacy interest on behalf of the decedents, unless a probate is opened and they are serving in a personal representative capacity. Again, I understand you not wanting pictures of your child's body just out there completely unblurred and unedited. I understand if you don't want stuff on their nightstands to be showing or their clothes that are on the ground to be showing. I understand that. But again, when it comes to certain photos, you can put a little box over where Maddie's under things might be on the ground. You can put blurring and editing around where their bodies are so we don't see specifics. But to say you can't show anything in any of the house whatsoever, the common areas, it doesn't matter, that you can't show anything outside, including the vehicles, because they belong to them, you're just going way too far. Just way, way, way too far. Interestingly, in arguing that plaintiffs have no privacy interest to establish standing, the city believes that it struck the appropriate balance in balancing the plaintiff's privacy and the interest of informing the people. The city's actions in blurring certain portions of the investigatory records prior to disclosure and balancing plaintiffs' and the public's interest cut against its standing argument. Well knowing that the presumption under IPRA is full disclosure, when asked why they took affirmative action to blur or redact the initial disclosures prior to any court intervention, remember, I just said that. We've been seeing this going on even before the court did anything about it. The city responded that it did so in reliance under the exemption under IC 741241C, thus agreeing that if plaintiffs had no privacy interest to assert on their own behalf or on behalf of the decedents, it would have been unnecessary to blur or redact the records. Instead, under its statutory obligation, it was required by law to disclose investigatory records on request with such redactions. Yeah, okay. So basically they're saying that you are arguing an argument that takes away the point to your own argument because of the actions that you took while making your own argument. That's exactly what I meant by they've been doing these redactions even beforehand. Because let's be so serious. If there were no redactions whatsoever done to those photos, we would have seen an unblurred photo of Ethan. We would have seen more actual detail. We wouldn't have gotten body cam that was silenced and had a whole bunch of beeps in it because they didn't want us to hear anything. We wouldn't be getting interviews released while everyone's faces are completely blurred and you can't see what they're doing with their hands. They have been hiding things since before there was a court order for them to hide anything. They put all of these things, all of these restrictions on things before anyone ever said a word about it. Why? Is it because they were already planning to hide something and then, oh, now we need somebody to come in here and put a paper trail on some stuff? Okay, well, you started doing things before there was a paper trail. So if that was the plan, it definitely backfired. I'm so tired of all the secrecy in a case where somebody is already pled and is serving their life sentences. Why are we still hiding things? While plaintiffs are considered victims and afforded certain rights as set forth in IC 19-53065A, the court finds IC 74-101-17AI does not have application in this particular case. The information to be disclosed is not being used to identify, locate, or harass a victim of an alleged crime of mass violence. There is no alleged, suspected, or unproven crime. The victims are known, located, and the murderer has been convicted and sentenced to life imprisonment. Exactly what I said. All this is already out there, and there's already been a sentencing. So what are we doing? Likewise, disclosure is not being used to harass the victim, even if the term victim encompasses family members. That's correct as well. Because if the family doesn't have anything to do with anything, then it's not harassment because it's not doing anything to them in way of giving them any responsibility for anything. It's literally just about the crime scene itself. However, IC 74-101-17A does apply here and provides standing for plaintiffs to assert their claim. The Idaho Supreme Court has yet to address the issue of whose privacy interest is protected under IC 74-1241C or 74-101-17A, but cases from the U.S. Supreme Court that have interpreted a similar provision under the Federal Freedom of Information Act provide guidance. Under FOIA, a public agency shall make records available, except records or information compiled for law enforcement purposes that could reasonably be expected to constitute an unwarranted invasion of personal privacy. However, unlike IPRA, there is no definition of unwarranted invasion of personal privacy within FOIA's statutory scheme, instead leaving the issue of whose privacy interests may be asserted or protected to federal courts to interpret. Of interest, in National Archives and Rex Admin versus Favish, the U.S. Supreme Court held that FOIA recognizes surviving family members' right to personal privacy with respect to their close relatives' death scene images. In that case, the decedent's family members sought to be shielded by the exemption to secure their own refuge from a sensation-seeking culture for their own peace of mind and tranquility, not for the sake of the deceased's reputation or an interest personal to the decedent. See, I understand this. Because they're going to have people contacting them. They're going to have people trying to get them to answer questions about things. I understand that. But let's not pretend like that's not already happening. And let's not also pretend like them filing this and wanting all of this to be super secret isn't going to cause this problem anyway. Come on. So in this being the argument in this case right here, this National Archives and Rex Admin versus Favish for the Supreme Court, this was the decision that was made by the court. We think it proper to conclude from Congress's use of the term personal privacy that it intended to permit family members to assert their own privacy rights against public intrusion, long deemed impermissible under the common law and in our cultural traditions. This does not mean that the family is in the same position as the individual who is the subject of the disclosure. We have little difficulty, however, in finding in our case law and traditions the right of family members to direct and control disposition of the body of the deceased and to limit attempts to exploit pictures of the deceased family members' remains for public purposes. Family members have a personal stake in honoring and mourning their dead and objecting to unwarranted public exploitation that, by intruding upon their own grief, tends to degrade the rights and respect they seek to accord to the deceased person who was once their own. This well-established cultural tradition, acknowledging a family's control over the body and death images of the deceased, has long been recognized at common law. And, it has been, honestly. It really has. But to go so far again as to say, I don't want you to show anything about the inside of the house whatsoever. I don't want you to show the alcohol containers. I don't want you to show anything outside, meaning the vehicles in the parking area and everything that's already been out there for 3 years. It's just taking it too far. And I can't let that part go because it taints the argument, in my opinion. Further, while not controlling, a district court in Ada County also concluded that family members of a deceased person have a right to avoid public disclosure of their deceased family member's corpse and other death scene images that would impugn the character of the deceased or of the family's memory of the deceased. For the argument in this document right here, to also have other information about how, in order for them to make decisions on what they wanted kept private, Karen Laramie and her attorney, and then here comes the Chapins, of course. In order for those decisions to be made, they looked at crime scene photos. They looked at body cam in order for them to make the decisions that they made. So if they've already seen it, then I don't see how this could be an argument if they had to go through it in the first place in order to argue their argument. You know what I mean? Like, we already read that in here. So again, this feels like a redundant argument. Here, plaintiffs seek relief both for their own privacy and on behalf of the decedents. Whether the privacy interest of the person identified is the decedent or the family members of the decedent, plaintiffs have established a recognized privacy interest in preventing disclosures of images or videos depicting their deceased family members in the death scene that would impugn the character of the decedents or their memory of them. Therefore, plaintiffs have standing under IC 741241C to bring this claim. Number 2, plaintiffs have proven their privacy interest in preventing disclosure of certain investigatory records without additional redactions outweighs the public interest in disclosure. Having established plaintiffs have standing to bring this claim, the next inquiry is whether their interest outweighs the public's interest in disclosure, as stated in Favish. So the case that we've already read the U.S. Supreme Court ruling in. Our ruling that the personal privacy protected by Exemption 7C extends to family members who object to the disclosure of graphic details surrounding their relative's death does not end the case. Although this privacy interest is within the terms of the exemption, the statute directs non-disclosure only where the information could reasonably be expected to constitute an unwarranted invasion of the family's personal privacy. The term unwarranted requires us to balance the family's privacy interest against the public interest in disclosure. Therefore, the weighty privacy interest family members have in death scene images of close relatives must be weighed against the public interest in disclosure to determine if disclosure would result in an unwarranted invasion of privacy. There can be no doubt that the photographs, video, audio, and other investigatory records in this case are incredibly disturbing. The records are difficult to digest and provide a raw view into the horrific tragedy that occurred on November 13th, 2022, that impacted plaintiffs, a college community, and the world at large. Prior to releasing these records, the city took measures to blur the decedent's bodies to prevent an unwarranted invasion of personal privacy while balancing the public's interest to comply with its statutory obligation. Plaintiffs have a recognized privacy interest, but on balance, the public has an interest in the investigatory records concerning this horrific tragedy and how the investigation was conducted. Regardless, each set of investigatory records identified by plaintiffs in their complaint, their interest must be weighed against the public's to determine whether release would constitute an unwarranted invasion of personal privacy, not just a warranted one. Plaintiff's privacy interest on preventing disclosure of the death scene images that would impugn the character of the deceased or plaintiff's memory of them or continue to re-traumatize them, causing extreme emotional distress, outweighs the public's interest in how the investigation was conducted or the scrutiny upon government action. Even the city's action in performing certain redactions supports this conclusion. No, it doesn't. It proves that they're trying to hide something. Again, they're not showing us the knife sheath. They're not being honest about timelines. And after the sentencing was over, they gave us 0 answers. And to this day, they have given us 0 answers. And to this day, we are still waiting for more documents from the court to be unsealed, and everything is being filed under seal to this day. This is absolutely wild. There is little to be gained by the public in seeing the decedent's bodies, the blood-soaked sheets, blood spatter, or other death scene depictions, whereas the dissemination of these images across the internet and in public spheres where plaintiffs may come upon them by happenstance has already occurred, causing them extreme emotional distress as an unwarranted invasion of personal privacy again. Blur the bodies, but let us see the scene. Blur the bodies, but let us see the scene. Let us see the knife sheath. There's a middle ground here. They're being unreasonable. The city has blurred certain portions of the investigatory records, but additional redactions are necessary to ensure there is no unwarranted invasion. The blurring is simply insufficient as it still allows the viewer to see the outline and contours of the decedent's bodies and invites, rather than dispels, any speculation about how, where, or why they were positioned. Well, that's because we're trying to see if there's consistency. What's the problem? When we're being told certain things in a report that's being written by the people that were there as these photos were being taken, we are expecting the images to mirror the reports. So it's not our fault that that's not happening. It's y'all's fault for being crappy investigators, and the fact you're sitting here saying this proves that you don't want to be held accountable. The fact remains, the investigation and the criminal case are closed. Releasing these records will have minor effect upon those who continue to be perplexed by the facts or fixated on unfounded conspiracies, whereas it has and will continue to have profound effect upon the decedent's loved ones. What conspiracies? We want information that matches your documentation, and you have yet to provide it. It's not our fault you like to sign off on things all willy-nilly without double checking things, Miss Ma'am. The city may disclose the investigatory records in this matter, but must black out any areas within the images, photographs, video, or other media that depict any portion of the decedents or their bodies and the blood immediately surrounding them. And I'm sure they're going to say, oh, the knife sheath was in a pool of blood. Sorry. There was blood around the knife sheath, so we can't show it to you. Watch. It's going to be so ridiculous. Contrarily, the court cannot find plaintiff's privacy interest outweighs the public interest concerning the dissemination of audio, video, or photographs depicting the interior of the bedrooms, except as provided above, the exterior or interior, including rooms other than the bedrooms of the residents, meaning the living room, the kitchen, the bathroom, common areas, hallways, The personal property and items of the decedents found inside the interior and exterior of the residence, including but not limited to containers of alcohol, undergarments, ID cards, and other personal items. Witnesses, including audio of crying, or statements of witnesses given to law enforcement officials, including statements evidencing their extreme emotions. Despite the horrendous nature of this tragic event and its distressing dissemination across the world, the fact remains that it was a quadruple homicide with investigatory records. These records, much like many law enforcement investigatory records, invade the privacy province of individuals, including suspects, witnesses, victims, and the like, and here, plaintiffs and others unnamed in this lawsuit. However, these records are precisely what the law affords the public to obtain under IPRA. Under the law and facts presented, the court cannot find the plaintiff's privacy interest outweighs the public's interest regarding these items, such that their release would constitute an unwarranted invasion of personal privacy. Further, releasing images that include alcohol containers, undergarments, ID cards, or other personal items of the decedents may appear embarrassing or reveal speculation as to what may or may not have occurred within the residence, but it does not impugn the character of the decedents in a way that constitutes an unwarranted invasion of personal privacy. Therefore, the city shall, upon request and in accordance with this statutory obligation, disclose the investigatory records except as to the death scene records noted above and those subject to any other statutory exemption or redaction rule. Okay, the next one. Release of certain images, video, and audio have caused plaintiffs to suffer irreparable injury, and there is a reasonable expectation that continued release will cause further irreparable injury such that a permanent injunction is warranted. This is not just about one person, one family. It is about the actual victims' truths being found, and not a single one of their stories has been actually told. None of their stories is consistent. There is literally zero information on whenever Xana and Ethan actually got home. We do not even have a concrete timeline. This is what it's about. The truth for the victims, not any of all this bullshit. But you can't jump onto YouTube, jump onto Twitter, jump onto Reddit, jump into your little private conversations that you have online with people, and then be mad whenever you see something. You're putting yourself right in the street. You can't be pissed off whenever you finally get hit by a car. As a final remedy, plaintiff's complaint seeks to permanently restrain the city from releasing the investigatory records described above pursuant to IRCP 65. To do so, plaintiffs must show threatened or actual irreparable harm and that there is a reasonable expectation that the wrong will be repeated. From the pleadings, the city does not dispute plaintiffs' claim that they have suffered irreparable injury due to the initial disclosures, even in their redacted form. Instead, the city contends it has made the only decision available to it under Idaho law by blurring the bodies and requests the court find the initial redacted versions of the investigatory records be publicly disclosed. And I'll also just add this real quick. You can't go on Amazon series doing interviews. You can't go to CrimeCon. You can't go on News Nation and go on all these other platforms that talk about crime constantly and then come out and want to do this. It's very flip-floppy, wishy-washy. You know what I mean? Irreparable injury is any injury that is impossible to remedy or repair. Plaintiffs have set forth undisputed evidence that they have suffered and will continue to suffer irreparable injury, including extreme emotional distress, because the city's release of certain records. More specifically, the injury sustained has physically manifested itself through sleep disturbance, shaking, and sobbing. It shouldn't be what's out there in the media. It should be just the simple fact that this shit happened in the first place. While it is likely plaintiffs have suffered these same or similar injuries prior to the city's disclosure due to the trauma they've endured from underlying circumstances over the past several years, exactly what I just said, the city has not disputed that its initial disclosure of video, audio, and photographs in their redacted form caused plaintiffs the irreparable injury claimed. As such, plaintiffs are entitled to relief. But you had to go through them all just to have this argument yourself. Like, you were physically like, I need to review everything so I can make a decision. After complaining how looking at all these things hurt you so bad, you then specifically asked to view them privately in order for you to make your decision. Like, am I wrong in that thinking? That sounds like that's exactly what's happening here. I don't know. Okay. Conclusion. For the reasons set forth above, the city's disclosure of certain investigatory records would constitute an unwarranted invasion of personal privacy. Plaintiffs have established the disclosure of such records has caused irreparable injury, and further disclosure will result in the wrong being repeated. Therefore, plaintiff's complaint for a permanent injunction is granted in part. You see what I mean? They were trying to block anything inside the residence, even the common areas, anything outside, which to me means like the vehicles. They even wanted the beer bottles, the alcohol bottles to be blocked out. Again, when you start asking for things that are a definite, obvious reach, it's hard for me to stay reined in on your basic argument because all I can think about is the frivolousness. And again, I understand why the parents of some of these victims might want some of these things privated, redacted, not shown to the public in full. I do understand that. But when something like this gets filed, and there's already something happening like this, and there's already all of these secrecies, there's already investigations into a leak, there's things still being filed under seal, we have no concrete answers for anything. All of this privacy and all of this secrecy and all of this, oh my God, don't let anyone see anything, it doesn't help the situation. If anything, this just puts more fuel on the dumpster fire. And it also means that they are going to further restrict the knife sheath. And the knife sheath is really the main thing that me and a lot of people are concerned about when it comes to this case. It has been over 2 months now, almost 3 months since we heard about this plea agreement, and we have yet to see a photo of the knife sheath, be it at the crime scene or at the lab, and we have yet to see the Amazon receipt. There is a lot of very simple things that they could be putting out right now that would cause a lot of the chaos to simmer down. And instead, they're refusing to give us basic, simple things. What is there to hide anymore? What is with all of the secrecy still? This doesn't help anything. But I want to know what you guys are thinking about all of this down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you have not subscribed already. And please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.